Okay. Well, I'm a judge certified in family matters in Munich, Germany. And in this presentation, I do not focus on the behavior of parents, but on the burden that members of various professions too often place on children and parents. There are very competent judges, very competent psychological experts, counselors, child and youth protection officers, lawyers, and so on. We all greatly appreciate their contribution to the well-being of the children and parents. At the same time, we suffer from the fact that too many professionals violate the best interests of the child and the fundamental human rights of the parents involved. Therefore, my interest today is in those actions by professionals who erect irrational barriers against the necessary development of the law and the psychological support system. We do the conscious or unconscious actions. Where do the conscious or unconscious actions of these individuals prove to be wrong? What are the problem areas inherent in the system? In doing so, I'm aware that my observations and analysis are based on the conditions prevailing in Germany. However, I'm sure that you will discover quite a number of similarities with the situation in your own country. Let's look at the judges. I place the judge at the center of consideration because it's from him that the decisive impulses determining the behavior of the other professions should emanate. We will see whether and how the behavior of the other professions in out-of-court counseling differs from their behavior in judicial proceedings. When a judge is presented with an issue in child custody matters or visitation matters, he or she should quickly find out whether the issue is one in which only emotions are boiling over. If so, good counseling and good therapeutic support can be an intervention tool and help resolve the issue. These are what we may call in this context the easy cases. I do not need to go further into these cases in the considerations here. In Germany, the Kochen practice, among others, is known in connection with the procedure in such cases. It attempts to return parental responsibility to the parents by means of counseling and therapeutic instruments. However, if at least one of the parents or both parents cannot be reached on the cognitive level, such approach fails. And these are the hardcore cases I want to talk about now. This includes the failing approach. This includes systemic therapy approaches, which require the ability to understand the role of the members within a system. It is my experience that all professions, including judges, rarely recognize these cases. And when they do recognize them, they are hardly able to solve them. My very subjective personal analysis of this problem has shown that the failure of proper case handling starts with a lack of clarification of the facts by many judges. They are very quickly to apply blanket assessment schemes without taking into account the specifics of the individual case. To put it bluntly, this means that the judges assume that the parents are in a phase in which they are not quite in their right minds and merely need to be brought back to a level in which they can restrain from their emotions through counseling. However, such judicial course setting fails to recognize that there are a considerable number of people who exhibit a significant potential for treatment-worthy pathological personality structures that are not amenable to intervention through counseling and therapeutic support. These personality structures include narcissism and borderline problems, which are often even considered socially acceptable in the overall social life and are falsely judged, for example, as supposed leadership and assertiveness. We do not reach these parents structured in this way with counseling and therapy offers. Either they sit out the counseling and therapy sessions for tactical reasons without changing so as not to suffer any disadvantages in the court setting, or they do not accept such offers in the first place. In the best case, they bow to a judicial pressure that seems overpowering to them in order not to lose access to the child or not to emerge from the proceedings as losers. We are familiar with this type of behavior of bowing to unavoidable judicial pressure under the heading of sanction learning, in which these parents do not internalize the underlying problem. Figuratively speaking, the reed bows to the excessively strong wind as long as it cannot avoid it. As soon as the wind dies down, it straightens up again. For the child, this means that during the phase of judicial pressure in which the reed bends in the wind, it is at the mercy of a parent who, among other things, uses double messages and unmastered emotions to convey his true attitude to the child. In doing so, he or she continues to expose the child to the conflict of loyalties to which the child has powerlessly succumbed. In such cases, only removal of the child from the household of the problematic parent enables healthy child development. The removal must be accompanied by competent therapy, both as help for the child and for the former target parent, and it would be ideal if the alienated parent would also take place in this kind of setting. After the above mentioned lack of investigations of the facts of the case as the first decisive judicial error, the second decisive misstep very often follows when psychological experts are commissioned. The judge appoints such experts because he considers him or her as a good expert. This means that the expert shares the judge's opinion. This concerns the problem of selecting the expert. Content-wise follows the incorrect assignment of tasks by the judge to the expert due to the judicially not determined facts. On this false basis, the expert is supposed to determine himself the real facts of the case and make a recommendation to the judge as how the judge should decide. Figuratively transformed to normal civil proceedings, this would mean that, for example, in a lawsuit concerning a reduction of the purchase price, the expert falsely should determine the underlying facts. If you could please be quiet behind there, it would not disturb the other people. Should determine the underlying facts, provide an expert assessment of the fact, and also give the judge a recommendation as to whether he should either dismiss the action in its entirety, dismiss it in part, or dismiss or admit it as a whole. We would certainly all describe such procedure as absurd and unlawful. At least under German law, the expert opinion is a piece of evidence. The expert may only be heard on facts established by the judge. The judge must work out these facts and make them available to the expert, and he must ask him specific questions about the ascertained facts. The expert must answer these if he is able to do so. If necessary, he or she can point out to the judge that he or she cannot draw up a proper expert opinion without a presentation of future facts, or further facts rather, that are still unclarified. He should then request further clarification of these facts by the judge. However, the expert must not independently clarify the facts of the case on his own authority. This is not within his professional competence and must not be assigned to him by the judge. The expert opinion is a piece of evidence, and the expert is not a private judicial investigator. In practice, however, the expert is often used as a quasi-private detective of the judge. Then he usually determines only very incomplete selective parts of the facts. This is often accompanied by the assertion that the specific facts of the case are not important anyway, because the objective is not to look at the past, but to look ahead. In doing so, however, the expert assumes certain factual structures on which he tacitly bases his results without disclosing them, or perhaps even without being aware of these assumptions. Therefore, he definitely makes a regnosis on the past events without making this transparent, and he builds on this faulty regnosis a faulty prognosis for future behavior of a parent or the parents and of the family development. Clearly, this approach is akin to Russian roulette. Perhaps the prognosis based on the flawed fact-finding is correct. However, as in Russian roulette, there is a high probability that it is wrong. The culmination of the expert's behavior then consists of the expert making suggestions to the judge as to how the judge should resolve the case, how the judge should evaluate the expert's finding, and what decision the judge should make. Under German constitutional law, however, the evaluation of an expert's finding is the sole prerogative of the judge. Moreover, as a piece of evidence in civil proceedings, the expert witness may not act as an advisor of the judge. He must only comment on established facts. Yet the practice is quite different. It supposes that the expert to himself find out the evidence and make himself the assessment of the evidence results. He's also falsely supposed to anticipate the judicial decision by making judicial proposals to the judge. These are all considerable violations of legal and even constitutional provisions, which were made in this way in good reason. Looking at guardian ad litem, a further area of conflict opens with regards to the legal status and conduct of the guardian ad litem. According to the will of the German legislature, he is supposed to be the child's advocate who presents and safeguards the child's subjective ideas in the judicial proceedings, but at the same time, he must also take the child's objective needs into account. This actually represents a conflict of interest that cannot be controlled. As a rule, it leads to the fact that the verbal statements of the child determine the actions of the guardian ad litem in the proceedings, and the objective assessment of the overall situation is disregarded. How should the guardian ad litem be able to take this into account if the judge, for his part, is not working through the overall situation? And in addition, there is this conflict of interest, in which the guardian ad litem is enmeshed. The position of the guardian ad litem is made even more problematic by the fact that he or she does not appear as an equal player with the other professions in the proceeding, but is often treated by the judge as a person of trust who discusses the case with the judge before the actual hearing. In this discussion, the procedure as such and the procedural outcome is determined. At the following hearing, it is then presented by the judge in the way that he asked the guardian ad litem about his opinion. And this opinion, of course, is often based on the judge's known opinion. In Germany, the guardian ad litem is elected by the judge for this position for this specific proceedings. This leads to an interdependence between the guardian ad litem and the judge. The guardian ad litem knows the judge's basic opinion. If he wants to be commissioned again by this judge to act as a guardian ad litem, he will do his best to act on the basis of this opinion, which he knows. The problem is the same with the psychological experts who are also selected by the judge in each case. The judge, for his part, takes the statements made on this basis by the guardian ad litem in the proceedings as an opportunity to point out in his decision that the guardian ad litem also shares the same opinion as he does. Not without reason, this approach can be described as intellectual inbreeding and intellectual incest that prevents a decision that is appropriate to the facts of the case. If we're honest, we must ask ourselves whether such proceedings are not shame trials. It certainly pains not only members of the professions addressed here to have to express this problem so clearly, but also us who are dealing with these realities on a daily basis. Youth welfare officers, the representatives of the Youth Welfare Office, who are supposed to be responsible for the protection of the child and adolescent, according to the legislature's conception, have usually not received the formal training for the problems related to the proceedings concerning alienation cases or shared parenting. They learn the job through training on the job, and this training is passed on from one professional generation to the next one in many team meetings. In practice, this means that blanket assessment schemes are based on from older professional members to younger professional members. As a rule, this means that the distinction already mentioned above between the situations in which counseling and therapy could help to solve the problem and the situation in which this approach is fruitless is not made, and therefore only prolongs the suffering of the children and the parents concerned. The result is relatively contentless statements by youth welfare officers, with sweeping assertions that the parents are incapable of cooperation and communication. This serves the myth of reciprocity, that means the unjustified assertion that the cause of a problem always lies with both parents. The general statements of the youth welfare officers can at best serve as a further fig leaf for the judicial justification that the youth welfare office employee also shares the opinion of the judge. In many cases, it would be more beneficial to the welfare of the child if the youth welfare office employee would honestly state that he or she lacks the knowledge to assess the facts of the particular case. Counsel, as long as the dispute between the parents is out of court, counselors are often called in. They can be employees of the Youth Welfare Office or other counseling centers. When we then experience that one parent uses the sessions at the counseling centers as a platform to present himself and his ideas without any progress being made on the underlying problem. Obviously, maintaining the status quo is the governing interest of this parent. In other cases, aspects of the actual conflict potential do come up. However, the counselors do not take them up and work on this conflict potential. The reason given is that the counselors have to keep the other parent on board. If they were to speak plain language here in terms of counseling, the other parent would drop out of the counseling situation and the setting would end. These consultants misjudge the task incumbent upon them. Their behavior leads to the fact that the problematic parent or the problematic parents feel themselves confirmed in their opinion and continue their dysfunctional and destructive behavior. The frequently misguided attitude of counselors to refuse counseling during ongoing court proceedings has a catastrophic effect on counseling. It would be extremely important, especially during the legal proceedings, that the parents receive counseling support to work through the events of the proceedings and thus contribute to finding a constructive solution. Attorneys. On the attorney's side, the handling of child custody cases only often resembles finger wagging. It seems to be all about who wins. Yet we lawyers learn in law school that from a criminal law perspective, we are not allowed to aid or to abet unfair practices. Child alienation represents psychological abuse of the child, which often leads to psychosomatic impairments. It is sometimes also associated with direct physical violence towards the child. It furthermore leads to damage to the other parent, psychologically, physically, financially, professionally, in terms of lost social interaction opportunities, and it extends to the impairment of a new partnership and a new family. We cannot, as lawyers, act as detectives in determining our clients' motives. However, we must determine the facts relevant to the decision with the possibilities available to us and submit them to the judge. If destructive behavior on the part of our client becomes apparent during the fact-finding, it is our task to lead the client to constructive behavior. If this is not possible, we believe that we must terminate the relationship with the client, just as consultants are not allowed to say that they have to keep the client in the boat, as at whatever costs. We are not allowed to want to keep our clients in the boat and continue to generate income with their destructive behavior. What has been discussed here represents only individual pieces of the puzzle from the large network of family law problems. In addition to many other puzzle pieces, however, I consider that these puzzle pieces to be quite decisive barriers that present a constructive approach in the legal dispute over custody and visitation. I thank you for your attention.